for joining us today. My name is Anna Garifine. I am the chair of the Managers Committee for MLRR, and I am joined by my vice chair, Dawn Morrow, and our wonderful board attorney and New Jersey Realtors attorney, Barry Goodman. So we welcome Barry today, and we are excited to get going and have him answer your questions. We know there's a lot of things that you guys had submitted, and you're welcome to submit some questions in the Q&A box as we go through this. So, Dawn, you have anything you want to start with, or?
No, in addition, we did take, some emails from you of questions that you had for Barry. We put them in a list. They should all be answered today. So if you can, give us a chance to get through them. We will be monitoring that list. And in addition, if there's something that just wasn't on the list that you thought of, we're also going to post the NJR, what's the website, Anna, that it's called? The
Legal Resource Library.
The Legal Resource Library, so that a lot of questions that may not have been asked today will most likely be there. And if they're not, you'll be able to ask those questions and they will follow up quickly with them. So you have a resource. We will put it in the chat or in the Q&A. I'm not sure where Lauren's going to put it, but definitely save that website for future use. And then we can begin.
Perfect. Hi, Barry. Welcome.
Welcome. I'm glad to be here.
Good. You're ready for our questions?
Well, we'll see. Don't make them too tough.
All right.
No,
so,
the tougher the better.
Yeah.
Good.
We're going to start off strong, so don't worry, Barry.
Yeah. So we're going to start off with the love letters topic, since that seems to be a big one right now. So if you could share with us, what should brokers be doing to avoid future liability with regard to using love letters, and how should we educate our agents on using them or not using them?
Yeah, love letters obviously a hot topic and has been for a while. And it's an interesting topic to me because I'm not aware of any lawsuits or complaints that have been filed as a result of love letters. However, it's gotten so much notoriety at this point. NAR has come out with a policy concerning love letters that we have to deal with it because it's out there and the public now knows about it. Just to make sure we're all on the same page, as you know, love letters are, letters that buyers are sent to a seller to try to personalize an offer. And when you have multiple offers and, it's all about price in the offers, buyers want to get an edge if they want the house, and they want maybe to let the seller know, for example, that oh, my family would just love to be in that house. I can picture my kids playing in the yard. I can picture us coming down at Christmas, and being in the family room. There are so many things that can be in love letters. It can be, my wife and I, can picture ourselves living there, and maybe it's signed by, a woman, so that it's a gay couple, because my wife and I, and these love letters almost uniformly reveal something about the buyer that will allow the seller to place that buyer in a protected class, whether it's sex, national origin, sexual orientation, familial status. There's always something in it. That's the purpose of the letter, to personalize it. And any type of person, I love your house because it's so close to the mosque or the temple, the synagogue or the church, so you're dealing with religious issues then. And the problem really is that even if the seller doesn't consciously register this protected class issue and doesn't make a decision based upon information that's in there that places the buyer in a protected class, that buyer, may feel that that was a factor, that because they put in there that, I want your house, because it's so perfect because it's so close to the mosque. So maybe the person is Muslim and they feel that, they're being rejected if they don't get it, or it's so close to the synagogue and maybe they're an Orthodox Jew and they think they didn't get it for that reason because the seller didn't want to sell it to them because they're in that protected class, and they file a complaint. And then suddenly you have to deal with it and the seller has to deal with that. And I will tell you, these complaints, most of which are filed with the New Jersey Division on Civil Rights, and I've had to defend a number of them. not based upon the love letters per se, but based upon the buyer feeling that there was some form of discrimination that was involved. I've had to deal with it, African-American woman, you know, a couple that was a mixed couple, you know, husband was white, wife was African-American, and they thought they didn't get the house because the wife was African-American. You know, and you really don't want to have to deal with these complaints. I will tell you that they're emotionally draining, and defending them, quite frankly, you have attorney's fees because you want to make sure that you, you know, prevail in them. So, you know, my advice is, and the advice of NAR, it's very clear. If you are a listing agent, you should say to the seller right up front, probably during the listing presentation, you should be telling your salespeople to do this. Discuss the issue of love letters. Say, hey, this is a hot market. You're likely, you know, to have some buyers and buyers agents who are going to submit these love letters. Let's agree right up front. We're not going to accept them. We're going to let buyers agents know and buyers know we will not accept them. We will not consider them. You really should be because I don't want you, seller, to have to deal with a complaint that's filed either in federal court with HUD, Housing and Urban Development, or with the Division on Civil Rights in New Jersey. I don't want you to have to deal with that. You know, I'm sure you're not going to intentionally discriminate against anybody, but it's a question of perception that we have to deal with. So as a result, that conversation should be had right up front with the seller so that, you know, when that love letter comes in, there's no mystery, there's no issue. You know, you can quickly say to the buyer, sorry, we're not going to accept any love letters. Our seller is going to only use objective information, you know, price, terms, contingencies, things like that to make a decision so that we don't have to deal with those issues. And I'm just gonna, you know, add one other thing. NAR in its guidance has said buyer's agents should not assist buyers in preparing these love letters. And that's fine and actually very, very good advice. But as a buyer's agent, you should discuss that with your buyer right up front that you will not provide that level of assistance. Because if you get to the point where you've been working with a buyer and the buyer says, I want to submit a love letter. This is the house. I want this house. Please, let's work on a love letter so that, and they're not going to call it a love letter, but a letter to personalize it. You know, that's a little bit late for a buyer's agent to say, oh, I'm sorry, I'm not going to help you with that. There could be a claim against that buyer's agent that the buyer's agent is breaching the buyer's agent's fiduciary duty to the buyer at that point because the buyer's agent didn't limit the fiduciary duties owed to that buyer up front. And so that's a little late in the game. And so you might find yourself as a buyer's agent with a complaint filed against you if that buyer doesn't get the house at that point. So that discussion should take place right up front with the buyer too, to avoid any issue along those lines. Dawn, your mouth is like open.
There's two follow-up questions, and I don't want you to go on to the next topic. There's two follow-up questions just based on what you just said with the buyer. Does the buyer's agent have a fiduciary responsibility to the buyer? If the buyer says, listen, I want you not, the buyer's agent did not have anything to do with writing the letter, but the buyer wrote the letter and they say, no, I want this submitted with my contract. Do they have the right to say, I want this as part of my contract, even if the listing agent says I won't accept it?
The buyer has the right to say that, but the question becomes whether or not the buyer's agent has limited the buyer's agent's role in submitting it. If the buyer's agent says right up front to the buyer, I will not submit love letters. I don't want to be part of anything that could potentially create liability for discrimination. You want to send a love letter on your own, you have to do it on your own. And I encourage offices to have a firm-wide policy about this and talk about it at your office meetings, because first of all, it'll make it a lot easier for your agents to say, we have a firm-wide policy. It's not just me, okay? And this is in accordance with the National Association of Realtors advice and guidance. So that's real important to have an office-wide policy. But the bottom line really is, it's how you define your fiduciary duty up front. You can always limit fiduciary duties as long as there's agreement to it.
Okay.
Barry, as a follow-up to that also, we're talking about love letters and buyers writing love letters, but a lot of times we're seeing buyers agents writing letters on behalf of their clients, telling the listing agent or the seller all about their client. So, I mean, obviously same thing, you have to limit what you're saying there, but best practices for that.
Best practices, don't do it. Don't do it. Because once you get involved in that, then as a buyer's agent, you may very well be dragged into the complaint that gets filed. I mean, typically the liability for discrimination in these instances under the Fair Housing Act and the law against discrimination is on the seller and the listing agent who consider the offers. But if suddenly, the buyer's agent has prepared something and included it, the buyer says, well, they're all in cahoots. It's a conspiracy against me. And suddenly the buyer's agent then is involved in the complaint. So absolutely that I would discourage under all circumstances.
And certainly the ones that add photos to it too, where photos.
Of course. And I will tell you, we talk about photo. One of the cases that I had to defend was a tenant who wanted a property. It came down to 3 tenants, and the landlord said to the agent, who I ultimately had to represent, you know what? I want to run background checks. Let me I want the driver's licenses of the 3 potential tenants, and let's run background checks. And one of the tenants, when she gave the driver's license to the agent, said, my son and I would love to, be in this house, this apartment. This is perfect for us, close to the school, blah, blah, blah. And so don't you know, the landlord decided to give the unit to somebody else, another tenant. That particular tenant filed a complaint with Division on Civil Rights saying, as soon as they saw my license, the landlord saw my license, he saw that I'm an African-American woman. And of course, I mentioned to the agent that I have a son, therefore there's familial status issues involved. And she filed a complaint saying she did not get that particular unit because she's African-American, because she's a woman, because of familial status. Those are the 3 grounds.
Okay.
So you can see how simple it can be in terms of somebody. And let's also step back for 1 second. And I'm sure most of you recognize this. We live in somewhat tumultuous times at the moment in terms of Black Lives Matter and people, expressing experiences of, at least I will say, perceived, just to try to be fair, perceived discrimination against them throughout their lives. You can agree or disagree as to whether or not there's been discrimination against certain groups, but certainly you have to acknowledge that they perceive this discrimination at the very least. And so many people, and it's not just African Americans, it's Muslims, it's Orthodox Jews, I could list lots of different groups, women, who come from a point of view that they've experienced discrimination. And so some people in those groups assume there's discrimination involved. And that's why they're more likely to file a complaint. So we have to understand that we take people as we find them, whether they're tenants or buyers. And that's why we have to be extra careful.
Barry, we have a follow-up question to that also that says, what is the difference if they meet these people in person during the showing? How does that affect, if they happen to see the clients physically, how are love letters any worse?
They're not worse in a sense. Well, love letters will provide more detail, but of course, if the seller, talks to the buyer at an open house or a showing, that could be the same as a love letter. The best practice.
Right.
The best practice. I'm sorry.
Sometimes we can't avoid that. It just happens. Maybe they're leaving as the client's coming in. So how, can't that seller make the same conscious or unconscious decision?
The answer is, of course. Best practices for the seller not to be there when the buyer goes there, when the potential buyers go there or potential tenants go there. But we all know it happens. Sometimes they're going to meet. And as the listing agent, you want to minimize any discussion between the buyer and the seller. It happens, and yes, it could be the same as a love letter.
All right.
not exactly a love letter, but along the same lines, we often see sellers agents rather, asking qualifying questions to a buyer's agent about, tell me a little bit about your client, or, wanting to know, do they qualify for a mortgage or whatever it may be, or, what do they do, that kind of stuff. So what is your advice on that?
Don't do it. It's one thing to talk about, do you have a pre-qual letter from a lender? It's another thing to start getting into issues about, how about your job, your job title. Now, let me step back for a second, because beyond love letters, discrimination, which deal with subtle discrimination potentially. The Fair Housing Act and the law against discrimination also can be violated if there's what's known as a disparate impact against one of the protected classes. So that's one of those tough phrases, if there's a disproportionate impact against one of the classes. The example I like to use in New Jersey is if a landlord, and I just had a discussion at lunch yesterday about this. If a landlord says, I don't want anybody who has a criminal record in my place. That's it. I'm not going to rent to anybody with a criminal record. Well, the problem is that Hispanics and African Americans in New Jersey are 3 times more likely to have a criminal record than a white person. So as a result, if you say, I'm not renting to somebody who has a criminal record, there's a disparate impact, a disproportionate impact against Hispanics and against African Americans. And you violated the law against discrimination in the Fair Housing Act by saying that. So if a landlord or seller wants additional information beyond what's in the 4 corners of the offer, you better, and it usually comes into play more often with a tenant as opposed to a buyer. You better look at as many different things as you can. So you're not focusing on just one thing. You can look at criminal record, you can look at employment history, you can look at how often they move around, from, renting from place to place. You can consider all of those different things. But if you just consider one thing in isolation, you're in trouble. I know one question that I had recently, a couple of months ago, was, well, we routinely will ask about job title, especially in the pandemic, because we want to get a sense of, is it likely that the person's going to be laid off? And, when you know the job title, it's, you have more information for that seller as to whether or not by the time the closing comes, they'll still be able to get that mortgage. And I discourage asking about job titles, because you know what? We still live in an era, and the facts bear this out. This is not my opinion, where women, face a glass ceiling, and yes, it's being broken more and more often, but it's still there. Women earn less than men. African Americans and Hispanics earn less than their white counterparts. Those are statistics that are there. And so as a result, by asking about job titles, you could be, creating a disparate impact on those other groups and therefore violate the discrimination laws. So you have to be real careful about those issues.
Well, it's interesting because it brings us right into our next question, which goes into tenants. But just as a follow-up to what you just said, somebody had asked in the Q&A, can a landlord, still see it? You're not discouraging them for asking for ID though, correct? In other words, you're renting to somebody, you want to make sure the person who filled out the application and filled out the lease agreement is actually the person they think they are. So it's not discouraged from asking for a driver's license or some sort of ID.
You know what? Yeah, look, if you're a landlord renting, to a tenant, you want to do a background check. You want to do a criminal check. You want to know how often they've moved around, and all those different issues. You want to know what the salary is. So can they really continue to afford it? And so at the end of the day, that's all legitimate. All I'm suggesting is if you focus on just one item or 2 items, each of which can, create a disparate impact on a group, you're on thin ice. The more issues that you look at, the more likely there's not going to be a basis for a discrimination claim.
Okay, that was a great clarification. Thank you. The second question is security deposits. We know there is obviously a 1.5 months maximum, but what is acceptable on short-term rentals where there is a price for the whole season. So for example, the summer rental is 30,000 and there's not a standard time frame. There's not a standard time frame of what constitutes summer. You know, how are we doing deposits basically?
Yeah, security deposits for short-term rentals. Let's be real clear. The security deposit law does not apply to rentals of less than 125 consecutive days, where the tenant has a permanent house somewhere else. Okay, so there is no rule in terms of how much security deposit can be taken with regard to a short-term rental. There's no statute that governs it. It's not like, security deposits for any tenancy that's more than 125 days or more. Okay, so if you're dealing with an annual lease, a semi-annual lease, there the security deposit law is going to govern, 1.5 months rent, but not for seasonal rental. So it's really up to the landlord, to make a decision as to how much is reasonable and how much the market will bear.
Okay, and for say a long-term rental, we've had this question over the years. I'm sure you've answered it more than once. Is about pet security. There's still a lot of realtors out there that don't understand that you can't take, from what I understand, more than a month and a half security deposit. So with a pet security, what fee should be added to the rent, if any, and how can they go around? How can they, add something to the rent or such to make it work?
Yeah, the one thing that you cannot do with regard to pet security is to take a refundable pet deposit. I don't care if it's a monthly refundable pet deposit. You take $100 or $200 up front and it's refundable if the animal doesn't create any problems. You cannot take a refundable pet deposit because that will be absolutely, without question, considered to be security deposit. And if you've taken a month and a half security deposit, you're over the limit then. Okay. Now, I'll tell you that there are some attorneys who feel that any pet deposit of any type violates the security deposit. I don't believe that's the case, because if it's non-refundable, I don't think it falls within the security deposit. I think it's additional rent if it's non-refundable. Now, the safest thing would be just increase the rent. Increase the rent, whether it's by $10 a month, $20 a month, whatever the number is, just increase the rent. It's part of the rent. And I think that that's the safest way to handle any type of pet. And I don't like to even call it deposit because it's not a deposit because it's not refundable. Okay, it's a fee, a pet fee at that point that you built into the rent, period. And you don't even have to put anything in the lease about it because it's part of the rent.
Okay.
We have a follow-up question to that, and it's, does the maximum 1.5 month security deposit only apply to realtors? There's they used an example that there's a corporation charging pet deposits over the security deposit.
The answer is it applies to any rental. It applies to the owner, the landlord, the realtor. It applies across the board. As long as the unit is being rented for more than 125 consecutive days or more, then it applies. It doesn't matter who's renting it, whether it's a realtor, whether it's the owner directly, the security deposit law applies.
Okay.
Good. So let's see. Our next topic, since we're on the topic of pets, is are there exemptions to buildings and communities that are pet restricted? So for example, the one person that asked this question talked about, are police dogs allowed, or is there a breed restriction that would apply? Police dogs are sometimes German Shepherds or larger dogs. So is there any rules against that or ways to get around that?
The answer is that in New Jersey, because this is a New Jersey statute, police dogs are treated the same as assistance animals under the Americans with Disabilities Act. And you must provide a reasonable accommodation. An absolute ban, let's say, against German Shepherds, it would not be permitted. You have to provide a reasonable accommodation. There have to be exceptions that are built in where somebody has, and it would be the same for an assistance animal. If the assistance animal, it's a legitimate assistance animal, and it's a German Shepherd, you couldn't enforce that policy. That's why it's very difficult, to talk about a policy that precludes types of dogs or types of animals. Because Americans with Disabilities Act, Law Against Discrimination, as well as the statute dealing with working dogs for police, specifically provide that you must make, you cannot have an absolute prohibition against them. Has to be a reasonable accommodation.
Barry, you brought up a good point when you said, well, let me just ask the question is, what does legally a tenant have to provide? Because when it comes to service animals, we hear there's different certifications. Is there a specific one that, isn't just a therapy dog? It is actually specific to what they need and it might not be a dog. Sometimes it's a different kind of animal, but
Right.
my point is, what should they provide legally?
Yeah, you certainly can require something from, somebody who's the attending person. And I'm couching that because it doesn't have to be a doctor. It can be a therapist. It can be some type of social worker. It's very broad in terms of who has to provide the note, but you can require something in writing, that the person needs the assistance animal. And let's be clear in terms of assistance animals, because there are two different standards we're dealing with here. You have the Americans with Disabilities Act, which deals with only service animals, like a seeing eye dog, an animal that is trained to perform a certain function, to assist somebody. And then you have the Fair Housing Act, which is much broader, and that's what you have to deal with. Because that deals with assistance animals or support animals, that sometimes called either assistance or support animals. And that includes the emotional support animals, whereas the ADA doesn't cover support animals. The Fair Housing Act does. And so you have to provide that reasonable accommodation. You can, for somebody who has an assistance animal or a support animal and it's legitimate. And we all know that sometimes people will go online and get these, I call them bogus, letters from doctors that they've never even met, or talked to, saying that they need an emotional support animal. Certainly you can challenge those to the extent that you can ask, did you ever meet with that person, et cetera. And if they never met with the person, the doctor or the physician, whoever wrote the letter saying they need the emotional support animal, never met with the person, they got it online, my advice would be to consult with an attorney to see, or have the landlord consult with an attorney to see whether or not, it can be challenged. Because there are certain things you can ask and certain things you can't. Like you can't ask what the underlying problem is. Do you have a psychological problem that really, requires you to have this? What's your emotional trauma that requires? You can't ask those kinds of questions.
What would be the proper question if I was bringing a tenant that had a service animal and it wasn't through the Disabilities Act? And let's make this.
Service animal is ADA. Service animal is a trained seeing eye dog or something like that. You have to provide a reasonable accommodation. So you could have a no pet policy, but that no pet policy goes out the window in terms of a legitimate assistance animal, which includes a service animal.
Okay.
You have to provide a reasonable. I'll give you an example of reasonable accommodation. One that came up at a seminar that I went to. And had somebody. They said this is one of the guiding things. There was a homeowners association, and there was a clubhouse, and there were a group that would play cards every day from 3 to 4 o'clock in the clubhouse. Somebody who had an assistance animal would come to the clubhouse every so often with the animal. It was a dog. And one of the people who played cards every day there was allergic to dogs and had a real problem. And the association said, you can't go near the clubhouse with that dog because of this person's allergies. It's not fair. And the ultimate result was a settlement under which the person who had the assistance animal could not go to the clubhouse between the hours of 3 and 4 o'clock when this person would be playing cards, but could go other times because it was determined that as long as the dog wasn't there physically, the person was okay. And so that was the settlement. That was the reasonable accommodation for that person with the assistance animal. You sometimes have to be very creative.
Okay. Do we have any follow-up questions to that, Anna?
No, we have some other ones coming in, but we'll save those for later. Let's go through our list and we'll
Just
get
one
back
other
to
thing then on service animals, because I don't want anybody to get confused. The Federal Transportation Commission, that's federal, maybe, I don't know, 6 months ago, 8 months ago, time is flying. I'm not even sure how long, it might even be longer than that. It came out with something that said that, on planes and in airports, they are going to limit the types of animals that can go on planes, because people were bringing emus, they were bringing pigs. I heard so many different things, one was a donkey, a small donkey that somebody brought on as, an animal. And the FTC said, you know what? No, we're limiting it to small dogs. And let's understand that the FTC is guided by the ADA, Americans with Disabilities Act, not the Fair Housing Act. So it's a narrower standard the FTC is dealing with, because they only have to deal with service animals. So it's easier for them to limit it. So if those of you who have heard about the FTC ruling on with regard to planes, don't get confused. That doesn't apply to you. You have to deal with the broader standards of the Fair Housing Act. Sorry, I just want to make sure. Sometimes I get that.
It's very confusing, and when it comes up, it's difficult, because like you said, there's some people that take advantage of it. There's some people that really need, if it's a service animal, they genuinely need them, and there's got to be protection for them.
Agreed, 100%.
So, understood.
We do have one follow-up question that just came in, and it's how do we handle potential buyers who come to, let's say, a Sunday open house with their service animal and the homeowner is allergic to pets?
Yeah, that's a great question. It does come up a lot. And the issue is that you have to provide a reasonable accommodation for that person who has a legitimate assistance animal. Now, what's a reasonable accommodation in the scheme of things for an open house? Maybe you offer that person to do a video tour of the house if they're agreeable to it. Maybe you have to discuss with the owner that, maybe we have to have the, if you're allergic, maybe we have the house professionally cleaned after the open house if any service animals come in, because the obligation, the burden's on the owner, to deal with that person, and the owner would have to deal with the cost of that cleanup. I would also suggest that when you deal with open houses and you're going to allow in some type of assistance animals, which fortunately or unfortunately, sometimes you have to do, that you take names of everybody who comes in during that open house, names and addresses, contact information. We had one situation where a service animal came in, urinated on a very expensive Persian rug. As I recall, it was $20,000+. Could not be cleaned, had to be replaced. And owner said, you know what, broker? You're paying for it. And the broker wound up paying for it out of the commission. Now, the broker had no way of knowing how to contact that person who had the service animal. There's only one person, so it had to be that person, And so you may want to have a list, make everybody sign in. You're not going to discriminate and just ask for, the name and address of the person with the service animal. A uniform, list for everybody, so that then you can follow up with that person who had the service animal and make that person pay.
I think, Barry, you mentioned something a little earlier that is definitely worth repeating, is that when it's not a service animal and it's, say, a therapy dog that we're working with the Fair Housing Act, that how important it is to not ask what the dog or pet is used for. What is there any question they can ask that would legally help them to determine if this is a situation the seller is willing to, or I should say the landlord is willing to work with, that doesn't put the agent in a harmful position?
The only questions really that you can ask are, the legitimacy of the letter in terms of whether they got it online and things like that, whether they ever met with the person who wrote the letter. And even then, quite frankly, you're skating in a gray area once you start asking those questions. They're legitimate. HUD said that it's okay to ask those types of questions.
That's a great question. So that's
Yeah.
that's a way of them at least, legitimizing, is this somebody that's taking advantage or a genuine situation without asking what their medical condition is?
That's right. And so, what you can do is say, look, until we can authenticate this letter, we'll make it, if and when we're able to authenticate this letter, what we'll do is, we'll set up a separate time for you to come back if and when we're able to authenticate it, and, accommodate them that way, and then consult with a lawyer. I don't want you to be making that decision, because you really want to deal with somebody who knows about these laws. It's because you walk into a gray area too
Sure.
easily, and I don't want to create liability for you.
Sure. Okay, perfect. I think we wrapped that up, right, Anna?
Yeah, no more questions.
No more questions, not total, but.
No, not on that.
You're not up to it, Barry.
So the next topic goes to, I guess this is an easy one, fences. And if your neighbor has a fenced-in yard and you don't, but you want to put in a pool, can you use your neighbor's fence on that side to fence in your yard? Or does it all have to be your fence? I guess that's up to different towns.
How friendly are you with your neighbor? This is really not a legal question per se, except to the extent that you should check with the zoning regulations in your municipality, because you have to see how it's worded. I'm not aware of, and I don't know every municipality, so I don't want to overstate this. I'm just not aware of any municipality that says you have to have an independent fence, on your own with a pool, as opposed to having it fenced in for safety reasons, so kids don't, get in. And you have to make sure that whatever, that fence is, however high that fence is, whatever type of fence is, it complies with all of the municipal regulations. If it does, I suspect that it's okay. My advice would be, if you have any questions as to whether it complies, and if you're fencing in the three sides or, two other sides of your house, the yard, you're going to have to check to see what the requirements are anyway. So check with the zoning officer and see whether that's okay. And the other thing I can think of is, if you do that, if you rely upon your neighbor, of course, you have issues in terms of if your neighbor takes down the fence, you have an issue. If the fence falls into a state of disrepair, such that kids can still get into the yard and get to your swimming pool, that becomes an issue. So you certainly have to monitor it and would have a duty to make sure that that fence stays in good repair at all times.
Perfect. You want to take the next one?
Yes, the next one has several parts to it, but it's all stuff I think the managers and brokers and owners are going to appreciate these answers to. Offers and disclosure. So we start with, can buyers make offers on more than one property at a time? I should say, can a buyer make offers on more than one property at a time with the intent to really only purchase one? So especially this kind of market we're having now, they're losing houses. So sometimes realtors are putting out multiple offers with the same buyer.
Sure. And you know what? There is no prohibition against it. Nothing in the code of ethics prevents it. Nothing in the law prevents it. The potential downfall, pitfall, if you will, would be if the offer gets accepted by 2 or 3 buyers and somehow it slips through attorney review. And so suddenly that buyer has 2 or 3 binding contracts subject to contingencies typically, but even in this market, a lot of buyers are waiving contingencies, in order to get the deal. So if it somehow slips through attorney review, that buyer could be on the hook for to buy more than one house, and may have to breach the contract and pay damages to the buyer, where this buyer has to get out of one of the contracts. So that's really the downside. There is nothing that prohibits it though, but it can potentially be a dangerous game in terms of liability, the damages of a seller. That's really the downside to it.
Any disclosures that have to be made that as a buyer's agent, should you be disclosing to a listing agent that you're making offers on more than one property?
The answer is there's no requirement, and quite frankly, I would not if I were a buyer's agent, unless I had the express and I'd want written consent of a buyer, I would never disclose something like that.
Okay.
Okay.
Again, with offers and disclosures, now as the listing agent, what are you required to disclose to a buyer's agent making an offer? For example, do you disclose, if with the seller's permission, can you just, can you disclose other offers?
The answer is yes. With the seller's permission, with the seller's permission, you absolutely can disclose other offers. You can, and once again, I'd want, it should be in writing from the seller that you can disclose the other offers. You should also, if you're going to disclose the amounts of those, you should have that, authorized by the seller, same way, writing. And if you're not going to disclose, that's a discussion you have to have with the seller. The seller controls disclosing those things. Now, one of the issues that comes up is where you have an offer from, you have a listing agent, comes a dual agent, maybe somebody else in the office, brings in a buyer, or maybe the listing agent brings in the buyer, but it's a dual agency regardless. And then you have other potential buyers from other agencies. And so there's always the suspicion that the listing agent is leaking information to the other agent and also to the buyer, in a dual agency situation. One thing that's very clear, if you are providing information to any buyers about offers, you provide it to all buyers. Okay.
And is that legally required?
And the Code of Ethics requires it. NAR has come out and interpreted the Code of Ethics to require it. And quite frankly, I would think that the Real Estate Commission, if faced with it in terms of dealing fairly with all parties to the transaction, and they consider that, they interpret that broadly, you can't self-deal in terms of the buyer who is through your own agency. You have to treat all buyers the same in that regard.
So if the seller, so just to clarify, if the seller gives you permission, and it's only when the seller gives you permission to disclose those things, if you're disclosing it to one buyer, whether it's your in-house or not, you must disclose it to all buyers.
That's right. That would be my opinion, and that's what NAR has said.
And that would be whether, and it could be anything about having to deal with if they're cash offers, mortgage offers. Can they actually, again, it would have to be with the seller's permission, they can even disclose what the highest offer is?
Absolutely. Because the seller may say, you know what, go out and use this to try to up the bid. Let them know that, somebody bid $650,000 and that's not acceptable. And see whether or not you can get me 700, 7.25, whatever the number is.
Okay.
See if you can use it to, to up the number.
So I think just to be clear on that, we want to clarify too, when we're talking about, Dawn mentioned, if you're disclosing what the highest offer is. So if you're disclosing what the highest offer is, you should be, we say we have to tell all of the buyer's agents, that we're telling them the same information, but you should also make sure you're telling the agent who made the 650 offer that you're disclosing that information to everyone else too, correct?
Correct. That's one of the buyers. That's exactly right. Yeah.
And I guess be careful too, because that could work against you where somebody might say, well, you know what, I'm out then. And, you could end up losing offers that way too. So
it could happen. And you know what, it's the same in terms of if, it's a multiple bid situation and the listing agent / seller asks for, best and final offers. It's not a best and final offer. When, you get in that $650,000 offer, as a best and final, the seller's not bound by it. The seller can still try to shop that number around, even if they've asked for best and final, until such time as the seller, signs the contract that comes out of attorney review. Seller's free to enter into another contract.
okay, I saw somebody was raising a hand for a question. So if you could just make sure you're putting your questions in Q&A, just a reminder. I do have a follow-up to that, and it's, can a buyer request that their offer details not be disclosed to other buyer's agents?
A buyer can request that, and the question is whether or not the seller agrees to it. It's just like anything else. If the seller says, no, you submit it to me and I control it, I decide whether or not I'm going to, use that or discuss it with other buyers, I should say. That's up to the seller. So, I mean, when that type of an offer comes in, I think that the listing agent should say, if that's the stipulation, you should know that, the seller's probably not going to, deal more seriously with that number. But let's be clear, if that number, using the example we have been, is $750,000, the seller says, yeah, no problem. I won't, let anybody else know, and I'm going to accept that offer. So it really just depends upon the nature of the offer. Oh, one other thing in terms of offers, that I just came across my desk maybe 2 days ago, that it was a listing agent who was including in the MLS, actually in advertisements, it was not in the MLS, it was in advertisements, that seller will not consider any offer that does not waive the attorney review provision, so that the contract becomes final immediately. Okay? If that's and it's not somebody from, Monmouth Ocean, area, it's someone from a farther north. But the bottom line is that if you see that, that listing agent is in trouble, because that listing agent is undermining the attorney review provision. It's not permitted. It would be the unauthorized practice of law. And so if you see something like that, one of your agents is doing anything like that, I just want to nip that in the bud, because not allowed. Not allowed.
So Barry, to that end, there's a couple of banks and, short sales, things like that, auction sites that are saying you have to use our contract and it's final and binding, and there is no attorney review provision to that contract. And it's usually just like a 2 or 3 page contract with no attorney review. So what's your advice on those?
As long as the real estate licensee does not prepare the sales contract, attorney review does not apply. Attorney review was created as an exception to real estate licensees practicing law. Because if you think about it, you are preparing a sales contract for 2 other people. Therefore, it's considered to be the practice of law. And the Supreme Court created an exception to allow you to prepare the contract, as long as that attorney review provision is in there, and the opinion 26 notice is there now. So it's an exception to the practice of law, but it's only where you, as a real estate licensee, are preparing. If the parties themselves prepare the contract, there's no attorney review requirement whatsoever.
Wow, that was a doozy. I got to tell you, Barry, that you saw that. So you kind of like stopped us in our tracks with, seeing that advertisement. That's amazing.
Yeah.
What about?
You want to do the Barry, because that's one of the questions that came up too, variable rate.
Yeah, variable rates, I will tell you that the Code of Ethics, Standard of Practice 3-4, imposes an affirmative duty to disclose a commission that is variable rate as soon as practical, is the standard. So if there's a variable rate commission involved, that in-house, it's going to be lower if it's a dual agency situation, lower commission. That has to be disclosed affirmatively to potential buyers under the Code of Ethics.
What if it's done during negotiation?
As soon as it's done, it should be disclosed affirmatively. And the problem is, if you already have offers from other brokers that have been submitted, that might be considered, and I'm not going to say yes or no, because the Code of Ethics, I don't remember specifically, but I don't remember that it covers that. But you cannot, one thing I do know, you cannot change the terms of compensation for other brokers once an offer has been submitted. That's clear. But if you, during negotiations, you say to the seller, accept my buyer's offer and I'll cut my commission, I'm going to say that could be an ethics violation. I don't want to say yes or no, because the code does not specifically address it, and I want to leave that to any ethics panel that may have to deal with it.
Well, there was a case study that we had brought up on a manager's meeting before, where we had gone back and forth with this. And apparently there was a case study where it was done during negotiation of the contract. and the seller had said to the agent, listen, I will accept this contract, but if I'm going to accept it, you need to, lower your commission to whatever. And the panel had decided that because it was during negotiation of the contract, it was considered not technically a variable rate commission. It was in negotiation.
And that makes sense. But the issue is, if there's another offer that's pending and that variable rate commission is negotiated in order to, get that in-house buyer and to undermine the other offer, that's where I think that you have a subtle nuance there.
Okay, makes sense.
Just going back to the 1 second, not to change things, but we had a follow up to the if somebody wrote a contract and it didn't have the attorney review period in it because it was not a realtor written contract, does state law allow for a 3-day right of rescission regardless of attorney review?
The answer is state law allows it, but doesn't require it. So I see lots of contracts that are not prepared by real estate licensees. Attorneys prepare them, and they include an attorney review provision. Not necessary, but if it's in there, it's part of the contract and one of the contractual terms.
Okay.
Okay, so
Well, when do you need to disclose if you have if there's an in-house offer, if dual agency exists on an offer and there's multiple offers, are you required to disclose that you have your own offer?
I can't, as I sit here, think of anything that requires it. No, I mean, that's up to the seller, in terms of disclosing offers, and that would include in-house offers.
So the seller can determine whether or not they want to disclose that they're working within the agency with the buyer.
Yes.
Okay.
And that should be in writing, in my opinion.
okay.
That's to protect the broker. That's what I'm saying. And there may be something in the real estate commission regulations, as I'm thinking of it, that requires it to be in writing. But whether or not there is, in order to protect yourself, you want something like that in writing.
And is there anything legally? Let me just follow up with this question before I forget to ask it. Can that same agent negotiate on both sides? Or do they need to get a third party involved, like their broker or another agent in the office? Is there anything legally requiring them to do that?
There's nothing that legally requires them to do that. Obviously, if they do negotiate both sides of the transaction with buyer and seller, they cannot provide any information to either party about the financial motivation or other motivation of the party as to sell or to buy. There's nothing that prohibits an agent from, negotiating both sides of the deal. However, I encourage brokers to do what I call designated agency. Many states have designated agency. We don't have it in New Jersey. The New Jersey Realtors requested the Real Estate Commission to create designated agencies several years ago. And so far it hasn't happened. And under designated agency, what would happen if we had it would be that the manager of the office or the broker would designate different people to negotiate with the buyer and the seller, so that there would be theoretically a wall between them, and that there wouldn't be any breach of confidentiality because you have different people dealing with it. I think that's good practice, even though legally we don't have designated agency, and it's not going to necessarily legally protect the broker. If for no other reason than it creates an appearance of separation, I think you have a happier buyer and seller knowing they have an individual representing them and not negotiating with the other party. Even though technically you still dual agents with all the duties of dual agents. But I think that you will have happier buyers and sellers, and that's a better way to handle that type of situation.
Okay. And I think earlier you had mentioned that going back to, if you're going to disclose to one buyer, you have to disclose to the other. So if there's other offers involved, if that dual agent is disclosing to their buyer, they have to disclose the same information to the other cooperating agents.
Absolutely.
Mm-hmm. Just going down my list here.
I know we're getting a few
Yeah.
questions here, so
Oh, here's one. When there are multiple offers and the buyer's agent, or maybe it's even an attorney review, one was accepted. The selling agent says to the listing agent, hey, listen, can I have the name of the attorney? So not only am I going to send this now offer to you, I'd like the attorney to have it too. So my client feels comfortable that their offer is being represented. Is this listing agent required to give them the attorney information?
No. If the seller approves it, the answer is yes. You can provide it. There's no requirement that the attorney, the attorney's name be provided at that point.
Okay.
okay, so just to clarify, if somebody negotiates a offer, a dual agency offer and lowers their commission at that time, not at the time of listing, are they required to disclose that to other buyers' agents?
Could you repeat that question? Because I actually was thinking about the prior question while you were saying that. I didn't focus.
Sorry. I'm just going through the questions here.'re getting a bunch of them coming in. So,
you know what? Before you ask that, let me just throw in terms of the last question, what I was actually thinking of. I apologize. As a practical matter, though, if it's an attorney review, the name of the attorney, will almost have to be provided if the other party is represented by an attorney, so that the attorneys can, if one of them wants to disapprove of the contract, they can send it to the other attorney. So as a practical matter, it happens, but there's still no requirement that that be done. As a practical matter of dealing with the parties, the attorney's name, typically is going to be provided. Sorry, Anna, go.
It's okay. So I actually might have asked the question wrong anyway, so it's good that we skipped it. The question is, if a buyer's agent lowers their commission, do you have to disclose that to other buyer's agents in a multiple offer situation?
If they lower their commission, so in other words, they're lowering it. In effect, then what they're doing is they're giving a rebate to the buyer of part of the commission.
Not necessarily giving a rebate, but just lowering the amount of commission that the seller would be paying to the buyer's agent. So now it's, let's say hypothetically, we're not fixing commission rates, but let's say hypothetically we have 5%, 2.5%, and 2.5%. Buyer's agent makes an offer and says, okay, well now I'm only going to take 1% on it, or maybe they're buying it for, maybe it's a family member buying it, and they say, okay, I'm only going to take 1%. So is it something that you have to disclose to other people making offers?
No, I don't believe that you do, because it's not a variable rate commission. But as a practical matter, the question in my mind becomes, let's say that the total commission is 5% in the example you use, and it's going to be 2.5% and 2.5%. And buyer's agent says, I'll take 1.5%. Listing agreement says it's a total of 5% commission. I am going to offer to buyer's agents 2.5%. Does the listing agent get 3.5% at that point, such that really the buyer's agent's effort is fruitless, if you will, because it's not going to get the buyer the house? The better way to do it would be to upfront, if the buyer's agent gets in writing with the buyer that there'll be a rebate to the buyer of 1% of the commission. And under the Real Estate Commission regulations in Section 17 of the Real Estate Licensing Act, which was amended 10 years ago, I worked on rewriting it to allow for buyer rebates, as long as you meet all the conditions that are set forth in Section 17 of the Licensing Act. So that would be the better way for a buyer's agent to handle it. Just give a rebate of 1% to the buyer, which, as I said, that has to be, agreed upon at the onset of the relationship, has to be in writing. New Jersey Realtors has forms to use for those rebates. And so that would be my advice, to make sure that the buyer really, benefits from it.
Okay. Yeah, this is a hot one. We're going to go into another topic soon. It's even, it's going to be just as hot. There's a lot of questions because this is the stuff that these agents are working on every day. So, there's how many, sometimes 15, 20 offers on a property now. And these things come up every day. We're trying to just go through here because we're getting a lot of questions on this subject. What should brokers do when attorneys in review place or remove items in attorney review addendum that seeks to limit the broker's rights to liens against parties to breach or default in a contract? I.e. buyer contingencies are all met and buyer or seller defaults the day before closing. I don't know if that is a follow-up to that.
Well, it's that was a little disjointed,
Yeah.
but the key there I heard was limits brokers' remedies in those situations. And one thing that's very clear is that the buyer and seller cannot, I emphasize cannot, limit a broker's remedies and rights in an agreement that is between the buyer and seller unless the broker signs off on it.
Okay.
They can't take away your rights. I see it all the time in attorney review that, buyer's attorney and seller's attorney agree that broker will have no right to an equitable lien at the closing if there's a commission dispute. They can't take away your right to an equitable lien. That's well established in case law that you have an equitable lien. And the way it works is that it attaches to the property as if it was recorded, just like a mortgage or anything else gets recorded, or a tax lien or anything else. It attaches to the property as of the time the contract is signed. And it stays on the property as an equitable lien until the closing and moves from the property to the proceeds at the closing. So your equitable lien is there under case law in New Jersey. Nobody can take away that right. And ultimately, if there's a default by the buyer or seller, you have whatever rights or remedies you may have. If there was a wrongful default, you may have the right to sue for a commission. If, let's say, the buyer pulled out at the last minute for wrongful reasons, you may have a right to sue the seller or the buyer under those conditions if one of them wrongfully breached. Because you performed. Sometimes that's going to be determined by what's in the listing agreement. But there's case law that says if there's wrongful, conduct, you may have a right to sue.
Okay, perfect. And are there any more questions on the topic of that we just discussed with offers and disclosure, or do we want to move on to the next one?
I think we can move on.
Okay.
So the next topic is escalation clauses. Do you consider an offer with an escalation clause to be a bona fide offer? And can you give us your thoughts on using them or not using them? And then I already have some follow-up questions that people were asking on this topic.
Escalation clauses are bona fide offers. There's nothing wrong with them. Nothing prohibits a buyer from including an escalation clause. Personally, I don't like them. And if I were a listing agent, I'd hate them just because of the chaos they can create. But they're legitimate. And you know what? Just like we talked about love letters, trying to give a buyer an edge, an escalation clause, can be beneficial for a buyer. And if a buyer wants to include an escalation clause in the offer, that's fine. It's up to the seller whether or not to consider that escalation clause. But it's a legitimate offer by a buyer, especially in a hot market. And whether it's, I'll beat the best offer by $5,000, $10,000, up to a total of $30,000 or $50,000 above, that's legitimate. There's nothing that prohibits it.
So let's see. Some listing agents are denying the consideration of an escalation clause. Can they do that? And if so, would they need seller's written authorization?
Absolutely. If there's an escalation clause in the offer, that has to be presented as part of the offer to the seller. It's the seller's decision whether or not to accept the escalation clause, not the listing agent. Any listing agent who does not present the escalation clause to the seller because they say, we're not dealing with escalation clauses, without the permission of the seller, they can't say that. The entire offer has to be presented to the seller. Otherwise, they're in violation of the real estate commission regulations, et cetera.
Interesting.
Dawn, was there any other parts to that were from the original question that we didn't hit?
No, wait, hold on. Yes, there is. So I think because we're getting two different answers over the past year about escalation clauses, that we were told that they are not a bona fide offer in some ways because they don't have a specific number. Yeah, granted, they'll go up to in increments of, but it's not a specific hard number. So it was not a bona fide offer. So somebody's asking to comment about that.
Yeah, I don't know who told you that it's not a bona fide offer, but I would strongly disagree with that opinion. If you want to have that person contact me, I'd be glad to discuss it with that person. Bottom line is, it's a written offer and must be submitted. It's legitimate, in my opinion.
Okay.
And I really don't have any doubt about that.
Okay.
Final answer?
Final answer.
All right.
So I just wanted to remind everybody, I know you guys are putting in questions in here and we are seeing them. And if they're not about the specific topic we're talking about, we will get to those at the end. We're just trying to get through a list of questions we have. That was the majority that were submitted ahead of time. So if anybody's wondering if I'm seeing them, we are seeing your questions and we will get to them as soon as we get through these few more that we have left.
Perfect. And this is being recorded too, Anna. So will we be providing the recording to them? So if they kind of like forgot what some of the answers were, they can go back and use this for their meetings and whatnot?
I believe that is the plan. So
okay.
Lauren says yes.
Lauren says yes.
Okay.
The next one is we're seeing a lot lately of waiving contingencies. It has become common that buyers are waiving inspections and appraisals. What is your legal advice on that?
My legal advice is that it's permitted. A buyer, once again, it's the buyer's offer. Just like with escalation clauses, the buyer can add things to what's in the New Jersey Realtors form contract or whatever contract you use for your company. And they can waive different provisions in it. That's a form contract. Now, so legally they can waive, inspection, they can waive mortgage contingency, appraisal. The issue really comes up in my mind, what the buyer's agent should do, where a buyer says, I want that house, I'm willing to waive these contingencies, especially something like, inspection contingency and mortgage contingency. They ultimately may not get a mortgage, so it may be a problem. Inspection may turn up something that, may cost them tens of thousands of dollars that they didn't know about, and suddenly they can't afford it when they buy the house. My advice to buyer's agents, if your buyer wants to waive any contingencies, that you confirm in writing to the buyer that you have advised the buyer that it is in the buyer's best interest not to waive the contingencies because of unknown issues that may be discovered by those inspections and, and other contingencies. But notwithstanding your advice, the buyer has instructed you to submit an offer waiving those contingencies. Because otherwise, you're going to be faced with a situation where, let's say it's a $50,000 bill, a $100,000 bill to repair something, and the buyer is going to sue you for not providing them with advice about waiving the contingency. Buyers say, I didn't know what I was waiving. I didn't understand it. In fact, I talked to my buyer's agent and I asked, and they said, yeah, a lot of buyers are waiving contingencies in order to get a house these days. And the buyer's agent never explain to me what I was waiving, what rights I was giving up. And especially if you're dealing with a situation where the buyer is not represented by an attorney, boy, that's a bad lawsuit to be defending. To a certainty, they'll include a claim under the Consumer Fraud Act, which is triple whatever damages they suffered, plus you pay the attorney's fees to them. So my strong suggestion is if they're waiving contingencies, put in writing that you have strongly recommended them, they not waive them, and but they have decided nonetheless that they're waiving them. So that you have that in writing if there's ever a lawsuit.
Okay. Just since we're on the topic of inspections, this is one of the questions that was in here. We have a situation where one of our listings failed a home inspection. Structural items and mold were found in the home. We were sent a copy of the home inspection and told about the deficiencies. The buyers backed out, and now we have another buyer who would like to make an offer. The question is, do we send them the home inspection report that we were provided with from the other buyer? It was not our buyer, but they did send us a copy of the home inspection. So are you even allowed to send a copy of that home inspection report to somebody? And would you advise that somebody does or does not?
My advice is definitely send it. And here's why. Real Estate Commission regulations require that you disclose all material information pertaining to the physical condition of the property. You have the seller disclosure statement, which provides certain written information. But where a previous potential buyer has backed out of a deal because of issues in an inspection report, whether or not you agree those issues are correct, whether or not the seller agrees those issues are correct, whether or not the seller has repaired those issues, because maybe the repairs were somewhat de minimis, even though the deal fell apart and the seller said, I'm just going to fix them. The bottom line is the issues that were raised in that inspection report deal with the physical condition of the property and must be disclosed, even if the issues were, to the best of your knowledge and seller's knowledge, fixed. What better way to have proof that you disclosed those material issues than providing the buyer with the inspection report? Now, some people say to me, whoa, the inspection reports say it can only be used in connection with my buyer, this buyer, and nobody else can use this inspection report. Well, once the buyer provides it to the seller, in my opinion, can then use it in this affirmative way of disclosing these potential issues. But as the listing agent, you have to make sure that if it's provided to a buyer, that you specify to the buyer, do not rely upon this inspection report for your inspection. We have no idea what instructions were given to the inspector by the previous buyer. This is just provided to you for whatever information it provides, and to disclose that this is what we dealt with previously. But you now have in writing that you affirmatively disclosed all of these issues dealing with the physical condition of the property.
Are they legally, but they're not legally required to hand that over if they choose not to?
That is correct. You're not legally required, but at the end of the day, there's no better proof that you disclosed it than providing them with the inspection report.
And Barry, just playing devil's advocate, because I know what everybody's thinking right now, is that you could have 2 inspection reports and 2 inspectors can have not completely, but maybe on certain items in the home have a completely different opinion of whether or not it's a problem or not until you get a licensed contractor in there to figure out if there is a defect or if it needs to be replaced or fixed. So I think that is mostly the concern, that we're going off of one inspector's opinion, even though they're a licensed inspector, and maybe they followed up on some of these things and they were not real concerns, because a lot of times the language is very vague, right? Would recommend you have, or this could possibly be an issue, or things like that. And that's what they're afraid of, disclosing actually misinformation. And the question is, are you harming yourself, as the listing agent, are you harming your seller?
Okay. I'm going to start with the first part. In terms of 2 inspection reports, they're totally at odds with each other. You don't get to decide, and the seller doesn't get to decide which is correct. That's the problem. Okay. Once an issue has been raised, you have to disclose it. You, as a real estate licensee under Real Estate Commission regulations, have an affirmative obligation to disclose it. Period. End of discussion. You don't get to decide who's right and who's wrong. Even if you bring in a contractor, who says, that inspection report's full of what? Come on, that doesn't have to be repaired. That's in good shape. There's no problem there. You're dealing with somebody's opinion. If when the buyer moves in, it turns out that that contractor was wrong, that the one inspector was wrong, and the buyer finds a problem that has to be remedied, you're on the hook for treble damages and attorney's fees under the Consumer Fraud Act. And it's an easy case. You don't get to decide. That's the bottom line. And, as difficult as it is, and not only you, the seller doesn't get to decide. It's fraud if it turns out that you're wrong and you're relying upon one opinion as opposed to the other, and that opinion you relied upon was wrong. Okay. Yeah, can you try to sue them, bring them into the lawsuit? Of course. But, that's not really where you want to be, defending a lawsuit like that.
So if something did fall apart, this is a question coming in, if something did fall apart, basically because of a home inspection or maybe a lack of a mortgage commitment or things like that, when can the seller legally keep a deposit?
that depends upon the contract, and most of these contracts are changed during attorney review. So that depends upon the contractual terms. But I will say that, if the parties agree that the seller can keep the deposit or any part of it, then that ends the discussion. But typically it's not agreement between the buyer and seller about keeping the deposit. And if there's not, then it depends upon the exact language of the contract as amended during attorney review.
So we hear agents say a lot in our business that, when they put the deposit down, they put something in writing, they're presenting the offer, that if you can't get your mortgage commitment, or if the seller and the buyer do not remedy any problems they have during home inspection issues, that your deposits will be returned. Would that be an inaccurate statement?
It very well may be, because it depends upon the circumstances. I have a case right now that it looks like it's going to litigation where the buyer could not get financing. And the buyer, let's just say, took a lot longer than the 30-day period in the New Jersey Realtors form contract. And so now there's a question. The attorney is holding on to its $150,000 deposit, and there's likely going to be a lawsuit about the release of that, where the buyer ultimately could not get financing.
Barry, right now we're seeing a lot of people, with all of this bidding war stuff going on, we're seeing people making much larger deposits up front. Would you say that that's, something that you should be counseling your buyer, that you're making a greater risk by doing that? I mean, they're doing it so that they can look like a stronger buyer, but at the same time, then they're putting that money on the line that they might not get it back.
Yeah, it's a balance, because let's face it, as you said, bigger deposit makes you a better buyer, a stronger buyer, if you will. Flip side, it's greater risk. If something happens and you can't go through with the contract, you have more money sitting there in escrow that's at risk. So the buyer has to make that decision as to how much risk they're willing to take.
Right. So just to be a little bit more specific on this one question, it did talk about, can a seller request to keep a deposit if a deal falls through on account of a buyer getting sick after the buyer receives a mortgage commitment? So they have their mortgage commitment, they're now to the point where they're just waiting to close, and the buyer gets sick, or maybe they lose their job, or whatever the case may be, and let's say a mortgage gets pulled because of it, or whatever the situation may be. Can they keep a deposit because of that?
The answer is, it depends upon the wording of the contract again. Typically, if the mortgage gets pulled, that may be mitigating circumstances, but you have to look at all the facts and what the wording of the contract is. I've actually had situations like that, and the court has to make a call as to whether or not to allow the deposit to, be retained by the seller. Whether the court's going to say, you know what, in this situation, they can't close because they don't have a mortgage. It got pulled because they lost their job. Okay, seller, you have an obligation to mitigate your damages, put it back on the market. Let's see how much you sell it for. And maybe you have no damages. And so you're going to have to return the deposit, because that deposit is not liquidated damages. It's not automatically the seller's. That deposit is to protect the seller against damages the seller suffers. And so let's say in the example I just gave, the seller there's a $150,000 being held in escrow right now as a deposit. Well, maybe the seller ultimately, sells it for $300,000 more and suffers no damages. Well, that $150,000 is probably going to go back to the buyer. But let's say that the seller sells it for $100,000 less. Plus the seller has carrying costs, mortgage, property taxes, maintenance, etc., for the 6 months or whatever it is, before they then can close. So the damages then are $100,000 plus the carrying costs, which may exceed the $150,000 being held as a deposit, and the buyer may be liable for all of the damages, $150,000 plus whatever damages will suffer. So it really depends upon all the circumstances.
So we have a couple, before we move to the next topic, we have a couple questions regarding attorney review and things like that. So one question is there anything that a buyer or seller, agent, whoever, any parties can do if you have a situation where attorneys are dragging their feet and something's been in attorney review for, sorry, not you, Barry, but dragging their feet and something's been in attorney review for, let's say, 2-3 weeks and we're not getting responses and things like that? What are our options?
Other than cursing them out, you know, look, there's really not a whole lot you can do, unfortunately, other than have your clients, you know, the buyer or seller, whoever's attorney is dragging his or her feet, really keep calling the attorney, finding out what's going on, and maybe pulling the transaction from the attorney. And we all know that this happens, you know. Look, good real estate attorneys keep the ball moving. They have paralegals who keep the balls in the air, et cetera, et cetera. But there are too many attorneys who are litigators or tax attorneys, don't know what they're doing, and things slide. There's nothing you as a real estate licensee can do other than nag the attorney and have your client nag the attorney. It's unfortunate, but look, there are good attorneys and bad attorneys, you know. There's not a whole lot you can do.
Okay. What do you do when you have a seller that does not want to use an attorney, or I guess, or a buyer, and they refuse to pay someone to prepare closing documents?
In terms of not hiring an attorney, I would, you know, send them something in writing that you strongly recommend that they hire an attorney. It is their right not to hire an attorney. So there's not much you can do about it. That's what the Opinion 26 case was all about. In South Jersey, about 80% of the closings occur without attorneys. You know, so that's their right not to hire an attorney. And that's what Opinion 26 was all about. But, you know, they refuse to pay closing fees. That's governed by the contract. You know, the contract, you know, says that the closing fees are going to be divided between the buyer and the seller, as at least the New Jersey Realtors form sales contract says that. I will tell you that typically that's changed by attorneys in North Jersey who are not used to that. That's the routine in South Jersey. It gets divided, and that's why we included that in the contract when we did the sales contract. But the long and the short of it is the contract governs whether or not they have to pay. Period. End of discussion.
Okay. Does the seller have the right? This is kind of going back to the inspection thing for a second. Does the seller have the right to refuse to receive inspection reports from third parties that they did not commission? So the buyer sends an inspection report. Can the seller refuse to get a copy of it?
Can the seller refuse to accept a copy of the inspection report? It would seem to me that that might be considered to be bad faith on the part of the seller. And in every contract, there's a covenant of good faith and fair dealing. You know, at the end of the day, you know, if the buyer is saying, I'm not going to close because of what's in this inspection report, it really doesn't matter, you know, whether the inspection report was, you know, prepared at the request of that buyer or they got it from some other party. I think that the seller has an obligation to deal with what's in the inspection report if that's what the buyer is using.
Okay. Then just going back to returning of deposits, this is a situation where someone had a buyer who received a mortgage denial, and then in the 11th hour, the seller had a situation where the buyer received a mortgage denial, and in the 11th hour, the sellers wouldn't return the deposit. They eventually listed damages, but they never remarketed the property. They just took a backup offer, and my client lost her deposit. So I'm a little confused.
It's very fact specific. I don't like to deal with specific fact patterns, but at the end of the day, it really, the seller can accept a backup offer or remarket the property. You know, but the seller has an obligation to mitigate damages. And I don't know what the damages were in that particular case. Did they approximate the deposit? If so, then that may be a logical solution. Or if they exceeded the damages exceeded the deposit. I mean, for example, the example I've been using, $150,000 deposit. If the ultimate damages suffered by the seller are $165,000, my advice to the seller is going to be: don't file a lawsuit for the extra $15,000. Keep the $150,000 and just move on, because the attorney's fees in the lawsuit are going to far exceed the $15,000 additional that you suffered. You know, just suck it up as a business decision. That would be my advice to the seller. So it really depends upon the facts.
I guess the question to that really would be also, what if the seller, you know, so let's say the buyer backs out for whatever reason or can't perform at closing, and then the seller decides, I've had enough of this, I'm not even going to remarket my house right now, I'm going to keep it. So how do they justify damages then?
Yeah, they'd have, if the buyer backs out, the seller has an obligation to mitigate damages. So the seller would be in a difficult position unless there's something in the contract that says that the deposit is what's considered liquidated damages. You know, some contracts will provide, and some attorneys will include an attorney review in the, when they change the contract, that damages will be difficult to estimate. And as a result, the parties agree that, in the example, $150,000 is a good faith attempt by both parties to estimate what the damages will be so as to avoid litigation about those damages. And so there's a possibility that if there's that kind of a clause, even though courts disfavor those types of clauses where you try to agree ahead of time what the damages are going to be, unless there's a good faith basis for it, you know, that might be a basis for the seller to keep the 150 and not market the property and mitigate the damages.
Good. All right, Dawn, I think we can move on to the next topic. We kind of eliminated a lot of the questions that were in the Q&A.
Yeah, we did really well with that. Independent contractor status. What is the likelihood the state will change New Jersey Realtors independent contractor status to employees, especially with the PRO Act pass, if the PRO Act passes?
The PRO Act is really not the issue here, okay, in New Jersey. I think that on the federal level, we're pretty set on the IRS regulations that real estate licensees, real estate salespersons are independent contractors for tax purposes. The issue in New Jersey, though, is a little bit more difficult, and it's two-tiered. One, we have legislation, and some of the legislation is unclear whether or not real estate salespersons are independent contractors or the salesperson. So I will tell you, for example, you have that in New Jersey, under workers' compensation, real estate licensees are considered to be employees. Because workers' compensation talks about employees, not independent contractors. And New Jersey Supreme Court, way back in 2000, said, you know what? Workers' compensation applies to real estate salespersons. Courts have also held in New Jersey the law against discrimination, which applies to employees, only includes real estate salespersons. Wrongful discharge doctrine includes real estate salespersons. And the Conscientious Employer Protection Act, also known as the Whistleblower Act, where you blow the whistle on employers' wrongdoing. There can't be retaliation. That also only deals with employees, but the courts have said that it applies to real estate salespersons. So you have four major areas of the law in New Jersey where real estate salespersons who otherwise are considered to be independent contractors are considered to be employees. Okay. Now, there are other statutes that now are under attack in New Jersey. And more specifically, the Unemployment Compensation Act specifically says that it does not apply to real estate salespersons, and for our purposes, who are paid wholly on a commission basis. That's the phrase that's in there. So if they're paid wholly on a commission basis, the Unemployment Compensation Act does not apply, and real estate salespersons are still considered independent contractors, not employees. There are two cases in the courts, one in front of the Appellate Division of New Jersey, before the New Jersey Supreme Court, both of which now say that the wage payment law, which does not include that phrase, that real estate salespersons are considered independent contractors if they're paid wholly on a commission basis. The argument is that because the wage payment law does not include that phrase, and the court previously has said that a different test, what they call the ABC test, which is how much the employer controls the salesperson, not to get into the weeds too much, that applies. There is now a challenge to say that real estate salespersons are subject to the wage payment law as employees. And in fact, there's a class action against Weichert that's pending, in which the plaintiff is alleging that all of Weichert's salespersons are employees for purposes of the wage payment law. That's the case that's in front of the Appellate Division right now. We're an amicus in that case, we, the New Jersey Realtors. And then there's a case before the Supreme Court, New Jersey Supreme Court, that's arguing the same thing. The case went to the Supreme Court based upon insurance agents who are, it's the same standard. You know, they're considered exempt from the wage payment law, from the Unemployment Compensation Act, if they're paid wholly on a commission basis. New Jersey Realtors has applied to be an amicus in that case because that case will effectively determine whether or not real estate salespersons are employees for purposes of the wage payment law. So we have that level that's in the courts. I am not going to, predict what the court's going to ultimately say. I personally think that we have the better argument that real estate salespersons are independent contractors under the wage payment law, the way things are set up. But I don't know how the court's going to ultimately decide it. So that's the court level. In the legislature, over the past year and a half, there have been a number of attempts by certain legislators and Governor Murphy to limit the number of employees in this gig economy, the number of independent contractors who will remain as independent contractors, and eliminate a lot of the exceptions so that people in the gig economy, and you hear the cases about Uber drivers and the like, and other types of drivers and people who, work for a company but are considered independent contractors. Well, the legislature and Governor Murphy have made attempts to really limit, and I mean severely limit, the exceptions to all of these people who have previously been considered independent contractors, and make them all employees. Now, the New Jersey Realtors, I will tell you, has been actively involved in maintaining the exception for real estate salespersons as independent contractors with regard to wage and payment law, unemployment compensation, and those issues. So far, it's been successful, but nothing has ever been voted on by the legislature. Each time it's gotten into committees, come out of committee, and then didn't go forward for some reason. But I'll just tell you, on the legislative front, New Jersey Realtors is on top of fighting to maintain the independent contractor status. But we have the battle on two fronts, legislature and courts. And who knows how ultimately it's going to play out. Long-winded explanation, a little bit too much legalese, I know, but I wanted you to understand that this is not an easy issue.
And it might not be resolved anytime soon.
That's correct. Although I do expect that at least partially, the Supreme Court, I would not be surprised if we get a decision from the Supreme Court by the end of the year or somewhere in that time frame. So stay tuned.
Okay, good information there. Next thing we're going to move on to is COVID. Now, we're all tired of hearing about it, but COVID rules in the office. So can or should brokers, and I know this is kind of a hard question to answer, but can or should brokers be requiring agents to wear masks? And apparently it's been a hot topic in some offices too, about brokers requiring agents to be vaccinated in order to be in the office, or to even ask the question about if someone's vaccinated, and does that become a HIPAA violation, or how does that vaccine conversation go in an office?
Yeah, and they're two separate issues in my opinion, although maybe related. In terms of wearing a mask, there's nothing that would preclude a broker from requiring masks, except if somebody has a health reason they can't wear it, and then they better provide something from their doctor, or a religious reason. I can't think of any religion that precludes wearing a mask. Okay. Same thing in terms of vaccinations. A broker can require any agent who's coming into the office, or all of its agents for that matter, to be vaccinated. The only exceptions are if the agent has a religious reason for not getting vaccinated, or a health reason. And once again, that agent would have to provide something from the doctor to the broker. Broker can require both of those with that minor exception of health issues and religious issues. The more practical issue in terms of requiring at least vaccines is that there are a number of people who just don't believe in vaccines, or afraid of the vaccines and afraid of the long-term effects, or have political beliefs. against getting vaccinated. And those people may decide to leave your office if you require vaccine. So it's not a legal issue, it's a business decision. I'll say that most businesses are strongly recommending vaccines for people. And maybe even saying, we don't want you to come into the office if you're not vaccinated, so as to not lose agents.
So from a liability standpoint, let's say a broker says, yes, you have to be vaccinated to come into the office. Now we have a vaccine that's not fully approved yet, and we're telling people that they have to be vaccinated in order to come in. Are we putting pressure on them to say, listen, if you want to come in and work, so does that become a liability for a broker owner?
Well, let me just step back, because the vaccines have been approved by the FDA. They're approved, okay? And statistics show that they're 99.2% effective, which is shocking to me, when you're dealing with the drug that really was created so quickly. But they have been approved. And so you are not creating liability if you, require that somebody be vaccinated at this point. You have the right to, require it. And the side effects, yeah, some people have suffered some side effects. It's, typically they're minimal, but, you can't minimize the fact that others, a small percentage of people have had side effects that are, meaningful. And so that's a business decision that the broker has to make in that regard, as far as I'm concerned.
Okay.
And I can tell you what some offices are doing is not requiring a vaccine, but if you've been vaccinated, the employer is asking, let us have the card showing that you're fully vaccinated. We will keep it in confidence, because it would be a HIPAA violation if the employer disclosed whether somebody's vaccinated. Okay, if the broker disclosed that, that's a HIPAA violation. And then say, if you're not vaccinated, we want you to have a COVID test within 3 days before you come into the office, and provide us with the results of that COVID test if you don't want to be vaccinated, so that we know that you're not carrying COVID and you're not going to spread it to anybody. And so we want the results of that test. So some employers are doing that as opposed to requiring the vaccination. And let's be real clear, HIPAA violation is by an employer. So if you have salespeople in the office and they're talking about who's gotten vaccinated and who hasn't, that's not a HIPAA violation. But it would be a HIPAA violation if the broker releases information about who's been vaccinated and who is not vaccinated.
So I'm talking to some other brokers in regard to this topic in the last week or so. I know one had said to me something along the lines of, we're requiring our agents to wear masks in the office, but if they choose to show us that they have a vaccination card, we're not asking them or requiring that they do, but if they choose to show us that, then they don't have to wear a mask in the office.
That's a perfectly acceptable policy. Under CDC guidelines right now, it's justifiable. And obviously this issue, it changes, as CDC, gets more information. I mean, it's a totally fluid situation.
So you're saying at the end of the day, a broker owner has the right to put certain requirements in place for their office. And then at that point, that could either be a liability if they lose agents that don't feel that they want to comply to that, or, that's something that they could take on themselves.
Yeah, and as I said, you can require that everybody be vaccinated. You can require proof of vaccination and or testing, before they come into the office. But all subject to if a person has a religious conviction against it, or there's a health issue that precludes them from doing it.
Gotcha.
Okay. Before we move to the next topic, since we're kind of talking about offices right now, we did have a question that came in earlier. It says, years ago, our committee reviewed how we would deal with the new existence of a VOW, virtual office. Was the status ever implemented, and is it an office status in existence? So I guess, can we just talk a little bit about virtual offices and how they're recognized?
You know what? I don't really deal with the VOWs all that much. Certainly they're in existence, but I don't really deal with them enough to really feel comfortable commenting on how they're operating and how well they're operating or anything like that.
Okay. All right, so we have,
I want to check on time, Annie, to see where we're at.
yeah, we're at 11:15, but we don't have any other questions. So maybe we could just hit this. We just have two things left. So procuring cause, this was a question that came up of, along the lines of just what constitutes procuring cause. I know we have a checkpoint of how to determine that, but if we could just talk a little bit about that.
Yeah, procuring cause is one of those amorphous concepts, unfortunately. I wish I could sit here and tell you every single thing that goes into procuring cause, but we'd be here for another 2 hours. No, none of us want that. The reality is that there's a, in the procedures manual for NAR, if you're really interested, there's a multi-page document that lists all the different factors that should be considered for procuring cause. At the end of the day, for the most part, it gets distilled down to who originated the offer. Did the agent who originated the offer see it through, or did they stop, dealing with the offer? And was there a gap during which they really dropped the ball in terms of the offer and somebody else picked it up? And who got it to closing and who's responsible for getting it to closing? All of that gets considered. The issue that I see, and more often than not, is where the offer submitted, deal falls apart, and then the buyer's agent who submitted that offer says, okay, let's look at other houses. And then 2 months later, that buyer goes back to the listing agent and says, I may want to look at it. Or some other buyer's agent shows them the house. And so the decision is, the real issue is during that 2-month period where the first buyer's agent dropped the ball and never went back and said, hey, you want to go back and look at that house? They never did anything to maintain the interest in that house. Does the second buyer's agent get earn the commission? That becomes that's a typical issue. So you have to look at it all. Who submitted the offer? How far did it go? Was there a substantial gap in terms of negotiations? And then who got it over the finish line?
So it's hard to comment on, I know we've gotten a couple.
Good explanation though, kind of cleaned it up pretty quick.
Yes, but we had gotten a couple examples of different situations, and without me going through each case and getting your opinion on it, the answer really is that there's a series of questions that would have to be answered in order to determine each case.
That's exactly right. Literally, the panel, when they decide these these arbitration issues, looks at all the facts involved. You don't isolate any fact. You don't isolate the fact that you submitted the offer. You don't isolate the fact that you're the one who got over the finish line. What happened in between has to be analyzed.
Okay, and then the last topic that I have on here that we've kind of beaten to death over the last year, but it is a big topic, and it's clear cooperation coming soon. So I don't have specific questions on it, but if there's anything that you want to share with us that you think that we should be aware of because you're seeing issues, we would love your input on that.
I'm not really seeing a whole lot of issues. I think the policy speaks for itself that, if you start marketing something outside of your office, you have to submit it to the MLS. It's a pretty clear policy, the clear cooperation policy. And it was intended to, shall I say, to deal with private MLS groups more than anything else, who were, you might have 4 or 5 brokers who were just sharing listings among themselves without even putting it on the MLS. And therefore, there was a real issue in terms of whether or not that type of a private MLS system was discriminatory. Because if you think about it, let's say that all the brokers in those offices were, white, whether male, female, doesn't matter, but it might not get out. The listings might not get out to Hispanic communities, African-American communities, Muslim communities, etc. And so there was a real potential, and still is, of discrimination by having these private listing groups out there. And they were becoming prominent. I know they were really prominent in California. There's one area in New Jersey where they have been prominent. And I will say that in that area of New Jersey where I'm told they have been prominent, that local board actually filed with the Real Estate Commission a request that the Real Estate Commission declare the clear cooperation policy to be null and void and unenforceable in New Jersey based upon New Jersey law, New Jersey Real Estate Commission regulations. That request was made over a year ago, and Real Estate Commission has not acted on that request. I'll tell you, NAR submitted something in opposition to that, saying that clear cooperation policy is consistent with New Jersey regulations, and there's no violation, but there's no decision from the Real Estate Commission on that particular issue. I will tell you that the commissioners, after being in an executive session and after considering it, said that they did not believe that there was a violation by the clear cooperation policy of New Jersey regulations, but there was, from what I understand, because I was not there, it was not an official decision. It was just comments, and so that may be why it just kind of died on the vine. But that's hanging out there, and those are my comments on clear cooperation policy. Unless there are follow-up questions.
No, I think that's pretty good. If anybody has a final question, we have like a couple of minutes left. I do have one in here. Is it permitted to take and I don't know if this is a question for you to answer, if this falls more on our own rules, but is it permitted to take a post-dated listing and begin advertising the property before the listing start date?
No.
Can't advertise something unless it's actively on the market.
That's exactly right. Once you start advertising it, you better have to put on the MLS under the clear cooperation policy.
Yes.
Well,
I guess I'm allowed to say this because he's commenting here, but Brian says we're working on that.
Yes, we are.
Thank you, Brian. Okay, so so a coming soon is not allowed to be advertised. A coming soon is allowed to be advertised. It's not allowed to be shown.
Yes, coming soon signs, if you put out a sign, exactly. I mean, for a coming soon sign to be out there or coming soon, be put in the MLS, I mean, you have to have the seller's permission to do it. You have to have a listing agreement with the seller that's enforceable. And you have to treat all brokers the same. You can't allow your in-house people to show the house or anything like that or submit offers unless you're allowing everybody to do it. But once you put out that coming soon, suddenly you're advertising it.
mm-hmm.
Okay, and yes, I thanked Brian, but Brian says thank you, MLS committee. So we do thank the MLS committee. As a member of the MLS committee, I can tell you that we have had a lot of very long meetings with a lot of great discussions and things that are all being worked on in the benefit of our members. So there's a lot going on there and things that will be coming up that we hope everybody will be happy with. Okay. Okay, this is a good one. For a coming soon, can you take a sight unseen offer? How do you ensure when you see a coming soon go under contract, and how do you enforce or know that it wasn't shown?
Yeah, that's tough to really find out. But if it's listed as coming soon, my advice to the listing broker would be to tell them that hold the offer until it's on the market. I've seen situations where it's coming soon, an offer is submitted while it's coming soon, and the seller says, "Whoa, that's a good offer. Let's accept it. I'm not going to play games. I don't know it'll do better." And so suddenly it's no longer coming soon. It's active, and it's under contract immediately thereafter. I don't know how you prevent that from happening, except for the fact that as the listing agent, I would say, you shouldn't be accepting, you shouldn't be reviewing that, offer at that point, although you have an obligation to provide all written offers to the seller. So you kind of have to, but, I think that maybe you have to get from the, something in writing from the seller saying, until it's active on the market, please, we're not accepting any offers.
Another statement.
Yeah, we're not going to consider them, but you have to have that in writing from the seller.
Barry, it comes down to what you've said many times in this meeting. about having that conversation with the seller at the listing appointment about what to expect, what are some scenarios that can happen, and how do you want to handle them before they become an issue. And
Absolutely.
you have that conversation, you put those things in writing, you're not waiting until they appear.
Yeah.
Agreed.
And I know as far as the coming soon things, and we're talking about sight unseen offers, you know, my understanding, and correct me, either of you correct me if I understand this the wrong way, but my understanding is if somebody does submit a sight unseen offer and puts in there a contingency that now you have to be able to see the property, whether it's in attorney review or whatever it is, that you now have to make that active and available for everyone to see.
That would be the best practice, yes.
Okay.
And
I think Lauren just put in the chat too, in case anybody's looking for that website for after this, if you want to go and look and you have questions, legal questions. I believe that she just put it in the chat for everyone to see.
New
Correct.
Jersey Realtors Legal Library, just as a reminder to anyone, if you want to go in there and ask questions, Barry actually answers some of the questions in the Jersey Legal Library when you submit them. So, you know,
And yeah, it's a great resource.
yeah,
Gary,
I'll
thank you so
say the
much.
Legal Resource Library has been working well, just to comment. You know, certainly on some of the tougher questions, New Jersey Realtors will send them over to me for my response. But one thing I have seen is that there's a tremendous repetition of questions.
Mhm.
So check out what's already in the Legal Resource Library if you have a question. I don't mind saying that I had an instructor who has historically, you know, sent me questions, and he's from the Monmouth Ocean Regional Realtors. And I finally said to him, do you ever check out the Legal Resource Library? Because a lot of these questions you're asking me, the students are asking, you know, that the salespeople are asking you, it's in there. And he looked it up and said, whoops, I'm sorry, Barry. Yeah, both of these questions were in there already. So it's a great resource.
Excellent.
So we actually, I think, got all of our questions answered, and I want to thank Barry for your time today. This was very informative, and we're grateful that you allowed us to record this and share it out to people. So thank you for that. Look for the recording, and if there's no other questions, that's it. We're wrapping up.
Thank you, Barry, so much.
Oh,
And
wow.
thank you for everybody that took the time today to sit in. It just goes to show you how many brokers, owners are out there, managers that really are passionate about this business. And it's great to see.
Yeah, questions were awesome. Thank you.
All right. Thanks, guys. We look forward to the next one with you. Stay
Take
tuned.
care, everybody. Stay safe.
Take care.